It's good to see you guys here. This is a really exciting moment. This is our first CHBA MCLE, so we're going to be applying for the credit so that we can continue to give these programs to our members, also highlight our members' skills. Today we have Andrew Billingsley. He is a family law specialist. He's been practicing law with his mom, Rosario Billingsley, for, I would say, 16 years. And so he has a great wealth of experience and knowledge. And so he was the best candidate to kind of start off our MCLE program. So take it away, Andrew.
Thank you for that nice introduction, Mahal. So what I'm going to do is share a couple of slides that I have set up right here. And so just wanted to have, really an open forum so that we can just have an engagement process where everyone is, active and not just listening to me talk or, just wondering about what's going on. And so I'm going to start this PowerPoint presentation. So as you can see, we're going to discuss dissolution of marriage cases, child custody cases, and support cases. You've heard from Mahal Montoya Billingsley, who was also an attorney. She's a civil rights attorney here in Oakland, California, and she is the MCLE chair for the Charles Houston Bar Association. And so let's just hop right into it. Dissolution of marriage cases happen every day. I see a couple of family law practitioners here in the Zoom, and so you are all familiar with how the process can work and how difficult it is to work with clients. And so I've just laid out a couple of issues that we can just delve into. And so first and foremost, obviously, one of the things that the clients are concerned about when they come in for either a consultation or to hire is the division of their assets. We will also go into fiduciary duty to spouses, financial disclosures, and failure to disclose, because we all know that that can happen in practicing family law. So the first thing that I'd like to highlight is the things that I talk to the client about are separate property and community property. Not everyone is aware of these concepts, and so we tend to refer to Family Code 770 for separate property, which states all property acquired before marriage or during marriage by gift, bequest, devise, or descent, and the rents and profits from that property are your separate property. Personal property that was acquired by either party during marriage in the state of California. There's also quasi-community property, which is property acquired during marriage in another state. And so do we ask that people mute their videos, mute their audio while we're presenting, just so there's minimal feedback? Thank you. So I was discussing separate and community property. And so the statute that discusses how property is divided when you go through a family law case is Family Code 2550, which states generally that the property acquired during marriage must be divided equally between the parties absent a stipulation or agreement. And so that may seem pretty straightforward, but we have a lot of situations where we represent clients, and even though you advise them of separate and community property laws and Family Code 2550, they have, just different ideas about how the process should work. And so another statute that I remind the clients about is Family Code 721, which outlines the fiduciary duty that spouses have to their partners, to the other party, during the litigation and even continue on after they've already been divorced. And we have a tendency to see that as well. And so you see here, 721 defines what the fiduciary relationship is, and you can see here the confidential relationship imposes the duty of the highest good faith and fair dealing with each spouse. And so the court treats this as if you see it makes reference to the corporations code. So it's akin to a business relationship. And so you're not going to proceed in the dissolution of your marriage on good footing with the judge or with the other party if you're not going to engage in fair practices and honesty with your spouse. And so that's just one of the statutes that we refer to when discussing the duties and responsibilities that pertain to spouses who are going through a dissolution of marriage. And so the next statute that we're going to take a look at is Family Code 2104. And this is the statute that we refer to tell the clients how they're supposed to make their disclosures to the other party. And so you see, we have the first form is a preliminary declaration of disclosure form in Family Code 2104A. And the next statute is 2104E, which I believe is relevant, and that describes the disclosure of your income and expenses on an average monthly basis. And so you have the I need declaration form, which is Family FL 250. And so that's where you have the reference to that form. Another form that is made that we refer to in the declaration of disclosure form is either a property declaration or a schedule of assets and debts. And you can look those up on the California court's website. But the last statute or last subsection that I would like to look at briefly is the subsection F, where it refers to the timeline in which you're supposed to serve your disclosures. For the petitioner, it's either concurrently with the petition or 60 days after filing and serving the petition, with the respondent 60 days after you file your response. And so folks may ask me, why does it take so long to get through a divorce process if, there's already these statutes that say that, we have a fiduciary duty to our spouses and we have to disclose everything for 60 days. How come we can't just be divorced after everyone discloses their assets and debts and fills out the appropriate forms? As legal practitioners, we know that doesn't always happen. People don't always, I reach out to clients frequently about, please give me the backup information for the schedule of assets and debts, or please provide me with your pay stubs, or please provide me with your tax returns. And it's not always an easy task or not always an easy assignment for folks. Most folks have jobs, or we have children, or we have other responsibilities. And so these things take time, and we don't always get things accomplished within 60 days. Another point that I find is remarkable is that the first time that you can be divorced is 6 months and 1 day from the time that the opposing party is served with a summons and petition. So there are a couple of statutes that we can refer to see deadlines and timeframes, but as family law practitioners, we know that it rarely, from my experience, it rarely happens in the 60 days or even the 6 months and 1 day. So the next topic we're going to talk about is folks who fail to disclose their assets, whether it's listing their income from, a rental property or a business that they may have. And so we hop into Family Code 1100H. So we have the remedies for a breach of fiduciary duty. And we see here that it makes reference to fraud, right? So the declaration of disclosure, you're signing under penalty of perjury. So there are penalties and sanctions for failing to disclose your assets and debts in a dissolution proceeding. And this is the statute that we make reference to when discussing that topic. And so this will lead us into a pretty important case that I found and that I've made reference to when speaking to my clients. It's the Marriage of Rossi case. And you can see that it's here. I should have asked, does everyone hear me okay? Can everybody see my slides? Thumbs up? Okay. I meant to check that earlier, but it just slipped my mind. So this is the Marriage of Rossi case, and you can see the case site, 2001 case, 90 Cal App 4th, page 34, and this is the Marriage of Rossi. What you can see here, I found the newspaper clipping from the Los Angeles Times in 1999, and this is the husband and wife, and you can read the trial court decision on the right. Essentially, trial court awarded the lottery winnings to the husband, even though it was considered the separate property of the spouse, of the wife, right? So this is a prime example of what can happen. The story, it's interesting. It's a fun story to read. basically, since it's not happening to any one of us, and I bring this case to the attention of all my clients to emphasize that, look, there are serious consequences for your failure to disclose, right? The court can award 100% of the asset that you did not disclose to the other party, and this is exactly what happened in the Marriage of Rossi case. There was a pool. At her job. There were a lot of employees who put money into a pool to play the lottery, and they won the lottery. And Mrs. Rossi's share was 1.3 million. She ran around and filed for a divorce. Didn't disclose her lottery winnings on the schedule of assets and debts. Husband was getting mailings to the home stating that we can, accelerate the payment of your lottery winnings. And he was very confused about this since he'd never heard of a lottery winning from his spouse. She made sure that the other mail with regards to the lottery was sent to her mother's house. And so she engaged in a series of activities and actions that were deceitful and that were not compliant with the code. And so for that reason, the trial court, the court awarded the lottery winnings to the husband, even though it was the separate property of the wife. And as you can see at the bottom, the Court of Appeal affirmed. And so this may seem like a drastic penalty for failure to disclose, but this is the current state of the law, and this is what I tend to remind my clients about when we're consulting or having, when they've hired us for a dissolution of marriage case. And so I just wanted to open it up a little bit. Did anybody have any questions about the marital dissolution cases or the Marriage of Rossi case? And feel free to raise your hand or just not shout, but ask any questions, and feel free to just let us know. Like I mentioned before, just wanted to make sure this is in. Okay, Kume? You can take yourself off. There you go.
Thanks, Andrew. Thank you for holding this session. And I kind of joined because while my firm doesn't particularly deal in dissolutions of marriage and family law, we do have insurance carriers that we work with who help with legal practitioners who do practice in that area. And there are a lot of cases where we have lawyers who had clients who don't disclose stock that they own that is at a certain value at one point that increases at a different point. So I was wondering if that kind of plays into the decision that the court will make when determining whether that constitutes as fraud. If it's like a small portion that bursts once the stock expands at a certain point, if that is ever taken into account.
That absolutely gets considered by the court. And you read through the form and it states that you're supposed to disclose the form is Schedule of Assets and Debts. You are required to attach any supporting documentation regarding the awareness of any assets or debts that may exist. And so some of our clients have, restricted stock units or stock options that may not have vested. And so, that's something that comes up in the practice, and people say, well, I don't actually have this asset right now. It's not something that I can draw on. It's not something that I can cash in. And I explained to the clients, I said, look, even if it's, in your eyes, it may not be something that you can currently use, but in the court's eyes and in other people's view, it's an asset that you acquired during marriage, or maybe you acquired it after separation. And so whatever the case may be, whether you believe that there is no value or there's some value, or that it's your separate property or your community property, you have an obligation to disclose that asset and as much information as possible on the Schedule of Assets and Debts form or the property declaration form. And so that comes up frequently with our clients as well. And that's pretty much what I tell them. You run the risk of losing the entire asset if the court finds out that you willfully failed to disclose, something that you have acquired during marriage, before marriage, at any time. You have the obligation, because at the end of the case, it could very well get awarded to you as your separate property. But you have the fiduciary duty to your spouse to dispose of that asset so that your spouse can do her or his due diligence to look into, the documentation or have further inquiry regarding the asset. And so that is an important point that comes up, with all of our clients. And so thank you for raising that point.
Thank you, Andrew.
Yeah. Did anyone else have any questions?
Andrew, I have a quick question. I don't, the ones that I know on here, I don't do family law, but just curious today. Is this the biggest potential penalty, or are there other penalties for failing to disclose, like fines, or is there a criminal penalty that could be associated with it since it's a fiduciary duty, or no? So
in the family law realm, this is the biggest sanction that I can think of, is that the asset that you fail to disclose is 100%. The court can award the 100% of that value to the other party, right? And so, based on the family law statute, that's the biggest penalty that I can think of. And sometimes folks will, request attorney's fees associated with the, discovery of the assets, or having to do additional attorney services because the party failed to disclose. And so the court can take that into account too. And so you can make a request, under Family Code 271 as a sanction, and, disclose how much your attorney has incurred by trying to track down these assets. And so that would be another way of getting some type of compensation for a party that fails to disclose in the family law action.
Thank you.
Sure.
Yeah, Andrew?
Hi, David. How are you?
Good. I would add something broadly to this topic. We all know that you come to court. If you come to court as a stranger, the first thing that the court's looking for is, do I have any reason to trust the person in front of me? If you come to court with a reputation, the court is looking to see whether they can rely on that reputation. That is also true of your client, who is almost always a first timer in front of that judge. All the court needs is one observation of unreliability, and everything after that becomes yes, but. Remember back yesterday when I found out that you were cheating on this. So from the standpoint of the litigant, it may be that the 100% penalty is the first and maybe the biggest, but certainly not the only penalty that they pay for an exposed breach of fiduciary duty. A good question can be asked here as to how exactly do you feel about entrusting a couple of children to this lying sack of something over here on this other side of the court who's trying to steal a lottery check. There's a very good question about what exactly is the essence of parenting, and if it isn't establishing in our children a sense of honor and integrity, I don't know what it is. So and with respect to attorney's fees, if there's a penny of attorney's fees that's associated with unraveling the fraud, obviously that's going to go to the defrauded client from the other client. But from that point on in the case, every time somebody's asking for fees, the judge is going to be thinking, I wonder if there's anything here I'm not seeing, or I'm not sure I trust what I'm hearing from this lawyer or this litigant, or I don't know, it's a close case. I'll err on the side of the person who's already been screwed once. So it is a spreading stain when you have a demonstrated breach of fiduciary duty. And it is a bigger spreading stain if it's a big breach than if it's a $100 breach. If it's a $100 breach, you can always explain it away as, I didn't think we were dealing with that fine of grain, or I forgot it, or sorry, Your Honor, it's my fault, not the client's fault. I just overlooked that in the documentation. I should have put it on the disclosure. It's when it's $1.3 million in a lottery ticket. It becomes the theme of the case, and you'll never get around it. You'll never wash that stain out. And from a lawyer's standpoint, if there's any indication that you were in on it, you don't ever want to be in that courtroom again.
Those are very important points. It goes to your credibility in the entire case. It goes to what David mentioned, goes to your parenting, right? So you're not only dealing with financial issues, you're also dealing with custodial issues. And so I thank you, David, for all those comments, because they're right on point. And these are things that we have to emphasize with their client time and time again, right? The court, this is not going to be the first time that the court is going to see you. This is not going to be the first time that this issue of non-disclosure is brought up. And, court is not very forgiving at times. And so we have to ensure that our clients, cooperate with what the statutes are. And, if a client insists on doing something a certain way, then it's really our obligation, duty, moral obligation to say, look, I'm not agreeing with the path that you want to take in this case. And so I think you should seek other counsel. And so it's a tough decision to make, if there's a client who insists on not disclosing certain things, or who wants to, just the behavior that you don't approve of, and that can harm them and harm their reputation, their credibility, and also, the lawyer's credibility, And so those are just very important key points that we just want to make sure that they're out in the open when we talk to our clients. And so thank you, everybody, for the questions and the feedback. All righty. So that segues perfectly into the next topic, which is child custody. So we have two types of custody. There's legal custody and physical custody. Another topic we will see very frequently is the best interest of the minor children. And then we'll talk briefly about parenting time, e.g. visitation. And so let's see here. The first issue is the two types of custody. So you have legal custody and physical custody. So you see here, legal custody pertains to important decisions regarding the children as to healthcare, education, and welfare. And then we have physical custody, which means who is taking care of the children, certain days of the week, holidays, and things of that nature. And so as a practitioner, we try to include as much as possible. There's a form, like I think it's a holiday schedule form, where you can, attach it to certain stipulations or court orders, where it outlines every single holiday that occurs during the process of the year, right? So some folks, they'll split Halloween, or they'll alternate Halloween, or it's important for some folks to have the birthdays of the children split, or I want to have the child on my birthday and you can have, our daughter on your birthday. And so these are things that come up frequently in family law matters. And so these are just things that we like to make sure people are aware of. Next subtopic is legal custody. And so you have joint legal custody, Family Code 3004, where parties share in the responsibility of, rearing and making the important decisions for the children. And it doesn't necessarily mean you have to agree. The court wants us to, in good faith, meet and confer on these important decisions as it pertains to, your children, such as, where is your daughter going to go to school in the fall, or, what summer camp, do you want to consider for your son? So all these things, fall under the umbrella of legal custody. We have the instance of sole legal custody, where, you might see this where there is a parent who is doing things that are detrimental to the child's best interest. And so the court may find that this is a situation where sole legal custody may be appropriate. I've also seen, I call it a hybrid. I've also seen a situation where the court grants one party sole decision-making authority regarding education or medical decisions, but would still maintain the joint legal custody designation. It simply would be a parent has the decision-making authority on such things that we mentioned. All righty, so let's go on to the next topic. So again, I think I may have mentioned this twice, but we talked about physical custody. So joint physical custody, you see here where it describes where it says that each of the parents shall have significant periods of physical custody, whether it's, split equally on a 2-2-3 basis, or, other forms of shared custody, that there's a physical custody designation, whereas the primary physical custody is where the child or children reside primarily with one parent and the other parent has visitation with the children or child. And so this is a topic that comes up very frequently. We've already seen it in the statutes, is the best interest of the children. And so you'll see the court make reference to this. You'll see parents, you'll see attorneys, and it just comes up all the time. And you see here in Family Code 3020 that the legislature finds and declares that it is the public policy of the state to ensure that the health, safety, and welfare of the children shall be the court's primary concern, right? And so I wouldn't necessarily say that there's an exact definition, but it just depends on what the facts and circumstances are for your case, right? And so it's our duty, obligation to, have the serious conversation with the client and, just get some background, get some history on what's been going on as far as caretaking for the children, and, what does the client feel is in, the children's best interest. So those are things that we discuss all the time with the client. Subsection B states that, it's also the public policy of the state to ensure that the children have frequent and continuing contact with both parents after the separation, right? And you'll see the last line, last two lines, except when the contact would not be in the best interest of the children. And so we have situations where clients come in and say, I want 100% custody. I want to make sure that, mother never sees the kid because she's, can think of a number of things. She's an alcoholic, she's a drug addict, or, all these things are allegations that will be made by either parent, right? And so it's our obligation to tell the clients, look, you could have these objections to how the parenting style worked, when you were together, or you still think that the parent is still doing things that are questionable in terms of, as it pertains to the best interest of the children. But the court has this statute where they want to ensure that the children have an ongoing relationship with the other parent. Just because you're going through a divorce doesn't mean that, the parents can't spend frequent time with the children, except if it's a detriment to their best interest. And so these are two, subsections that we look to. But again, you speak to your clients, and we try to get as much information as we can with regards to what's been going on in terms of the upbringing of the children and things that the parent may be concerned about. And so that's something that we look to. We look at Family Code 3100A to discuss parenting time. And you see here that it says that the court shall grant reasonable visitation rights to a parent when it is shown that the visitation would be in the best interest of the child. Again, best interest of the child is it appears throughout the family law code. And that's just something that we have to, make arguments about on a case-by-case basis. And it just depends on what the clients have told you and what the clients are telling us throughout the litigation. And so I see here a question on the chat. It says, is child custody an automatic part of the marriage dissolution, or is it only if it's contested? And so I always encourage parties to see if we can reach any agreements, see if we can stipulate the things, because it'll be easier on your heart. It'll be easier on your energy. Obviously, we always want to take into consideration the best interest of the child, but it's when you file the petition for dissolution of marriage, you check on the box that states that child custody is an issue, even if you don't need to have a hearing on the child custody or the custodial schedule. And so that's where, you just, you stay with it, who the children are, and even in the petition, you can state what you believe the custodial arrangement can be. And so it's always good to, if possible, obviously, if there's domestic violence, then, there's other considerations, but we encouraged our clients to say, let's think about what the custodial schedule is going to be after you file for divorce, after your spouse is served with the summons and petition. And so you can stipulate to what the custodial agreement will be in the future, but we still have to, let the court know what is going on. And so we have the next question here that says, does the court sometimes look to foster care cases on the best interest of the child standard, given that both courts use the same standard? And so I would definitely say that is always a consideration. It's best interest of the child, right? So we have that statute throughout the family code. And with regards to foster care cases, I would just have to rack my brain in terms of whether we would really see that in a family law arena, maybe under, it might be an dependency or something, but that would be something that I'd have to just address at another time. But thank you for bringing up that question. With regards to David's comment as well, so when you file a request for order and you want a hearing on child custody and parenting time issues, then in Alameda County, you're required to, there's mandatory mediation. And so you have a scheduled time where you meet with the child custody recommended counselor, formerly the mediator, who's a licensed counselor, licensed therapist, who will help the parties and assist the parties in trying to reach an agreement regarding a custodial schedule for the children, right? So at the beginning of the case, or when you file, you may not know what the other party is thinking, because you may not be in a good the relationship of the communication may not be there. And so you're given the opportunity, you're required to attend mediation with the CCRC, the Child Custody Recommending Counselor, at the courthouse, and nowadays it's by Zoom, and she will help, or he will help the parties see if there can be any agreements, and if there aren't agreements, then the Child Custody Recommending Counselor will make a written recommendation to the court as to what she or he believes is in the child's best interest. And so that is something that comes up in the child custody proceedings. And so one case that I talked about with Mahal regarding child custody is that a couple, maybe 5 or 6 years, maybe longer than that. So there was a couple, they were no longer together, and they had a daughter. The husband was in the armed services, right? So he was originally stationed in San Diego, and then mother moved up to the Bay Area. The father was reassigned, right? Father had primary custody, or the parties had joint custody. I forget what the exact order was, but the arrangement was, the court order was that the father had custodial time during the school year, mother had custody time during the summers, maybe some holiday breaks, and things of that nature. And so, given that father was stationed in the Midwest, and he just felt, I think he was living with his parents at the time, he felt that it was in their daughter's best interest for the daughter to continue to live with the grandparents, right? And so on the summer visitation, mother, exercised her visitation, and during her visitation time, she ran around and filed an ex parte emergency request for order, requesting that she have primary custody of the children because father is not looking after the children, and it's not because he's stationed in the Midwest, and the grandparents, they're not, whatever the allegations were. She said that she was the best custodial parent, and the best interest dictates or requires that our daughter should reside with me now in the Bay Area, now that I've relocated. And so that was tricky in a sense. At first it looks, wow, it looks very, it looks like a very difficult case to have to litigate, right? The mother is obviously, she's a biological mother. She's had custodial time with her daughter, and now we have a circumstance where she's filing in a different county, right? The original orders were in San Diego County. So we know that the court order or stipulation, whatever the order was most likely based on the best, based on best interest of the child at that time, right? So the original circumstance was the father was living with his parents in the grandparents' home, and obviously the grandparents had a relationship with their granddaughter. They were there every day, they shared meals, they did activities. And when the father relocated or was reassigned, mother filed for this emergency motion filed through the ex parte, requesting that the court immediately change custody so she could be the primary caretaker. And so in that circumstance, she's making this best argument, this best interest of the child standard argument, right? She's saying father's not there. And so what actually wound up happening was that the court, relied on the other San Diego court's decision, which was already in place, which might be surprising to some. So it's like, well, I could see a situation where it looks like father has abandoned, the child, and he's not, having the full care and responsibility of the child, then the custody should definitely be with the mother. And so that was, it was more of like a procedural issue, right? The court had already made its orders in San Diego. They had already done the best interest of the child standard. There's already a court order. And so even though the mother had made some good points about her being present, the fact of the matter was that there is already a court county really that had jurisdiction over this child, and there were valid court orders with regards to this child, right? And so the court's order was that this is not the appropriate forum, right? There's a valid court order in San Diego, and so if you want to contest the court order, you should go to San Diego and file a modification of child custody and or parenting time order request there in that county. And so it's really up to, a fact by fact consideration as to what's going on with the parties, with the parents. There's a statute for grandparent visitation, right? So we've had clients who wanted to have custody of their grandchildren because, and these are extreme circumstances where, the mother was really, she was murdered, right? And so the grandmother is stepping in, she wants to have visitation, she wants to have custody. So there's all different types of situations that we see with our clients. And, we have to just advise them of what the current state of the law is. And so that's why we have continuing education classes. That's why, it's important to talk to other practitioners and just have an open dialogue about your cases, obviously maintaining confidentiality. But, if there's questions that you have, feel free to reach out to any of your colleagues, that you trust or that, you just want to bounce ideas off of, because sometimes we don't know all the answers, but, and like I said, I'll try to go find that answer, right? If you don't have the immediate response for your client, that just may be something that I have to look into, and then let's schedule another meeting so that we can talk about this further after I've done some research. So that's always a good thing to do, is just to be honest. I talk from my experience as a practitioner, and I just try to share, my experiences with other folks, with my friends who are also attorneys, and so it's just important to have the open conversation about things. So does anybody have any questions about the child custody portion? Stop the slide share. Okay, I think it may have. Okay, so just wanted to, okay, sorry, I'm gonna go back. I must have pressed escape by accident. So let's go into the next.
Andrew, that David Levine has a question.
Okay, go ahead, David.
Yeah, just a real important component of custody and visitation. Custody is harder to change. Visitation is easy to change because day-to-day circumstances can change. But one of the compelling principles of custodial law is, if it ain't broke, don't fix it. And another is, don't let the perfect be the enemy of the good. So you have to use judgment when you are examining your own client's situation, and you have to be forthright and sober up your client about what their prospects are for unsettling an otherwise settled arrangement. Courts are of the opinion, they may or may not be right about this, but they're of the opinion that a less than perfect situation is probably better than a shuffling of the deck and a trying for something, maybe we can get something better out of this if we just change everything. They think that kids need stability. So may or may not be true, and may or may not be true for your kids, but judges are constantly looking for how not to change custody. The example you provided, it's not my job, everyone go to San Diego. There's a real test. If it's this important, you'll make your way to San Diego. If it isn't, you'll stop right here, and then we won't have to make a decision. So there's a lot of that.
Yeah, I think that's very important. It's a reality check for the clients, the truth of the matter is that you were in a loving relationship when you got married. You were both presumably raising the children, or, you know, even if you weren't married. And we have to focus on what's in the best interest of the children. You know, it takes, you know, you just have to take the ego out of out of the equation. You know, you have to think about, you know, your children. You have to think about the fact that you're in this litigation currently, and that you have the judge, and you have the mediator, and you have all these other folks who have, you know, who have their eyes on the children, who have their eye on what's best for this child. And so, you know, we encourage folks to make agreements if they can, right? But because you know your children, you know the other party better than we do. You know, I just met you. You came in for a consultation. You know, you're sharing a lot of private information with me, granted, but, you know, I can't mind read what's going on in the other party's head. You know, I can tell you what the judge has done in the past. You know, it may not always be the same going forward, but from my experience, you know, Commissioner Bichet makes decisions like this, or, you know, Commissioner Nixon, you know, Commissioner Clark. So, you know, it can all depend on, it all depends on what's going on for your particular child and the child of the case, obviously. And so you just have to really have a heart to heart with the client, and just, you know, just like David said, be forthright and just be honest with them, and just to let you know, no, these are serious situations that the court is going to take very seriously. And so, you know, if you're saying, oh, I want to move out of the state, or, you know, I don't want him to have him or her to have contact with our child. Well, you see, I already made reference to the legislature stating that the public policy is that the children have frequent and continuing contact with the other party. And so you get instances of alienation, or a parent who is not willing to share the rearing responsibilities. And so there's circumstances where the court may change custody in an extreme circumstance if you're not acting in the best interest of the child. Like David said, there's a high hurdle for that, but we just need to be mindful of that, and we need to tell our clients that, you know, the court doesn't look favorably upon bad actors. And so it's definitely a case-by-case basis, and, you know, it happens on a case-by-case basis, but we just want to be honest with our clients. And so the next topic that we're going to discuss is guideline child support. And so this is a question that comes up, you know, for married soon to be not married partners, and partners who were never married and who have a kid together, or children together, right? And so the court looks at Family Code 4057 for purposes of calculating guideline child support, right? You see here 457A that the formula is presumed to be correct, right? And there's a rebuttable presumption that may be rebutted by admissible evidence, again, case-by-case basis, showing that the application of the formula would be unjust or inappropriate, right? So first thing, well, one of the things that we do in a consultation is that we show the Dissolution software program to the clients, right? It's a software program that takes into account tax factors. And so it looks at the gross income of the parties, looks at the custodial time that is spent with each party, the custodial time that each party has, and other tax factors like health insurance deductions, union dues. We also throw child care expenses, add-on expenses. So there is, you know, there are a lot of different items that can be input into the calculation. And we want the clients to just be aware of all the responsibilities and rights that come with a family law action when it pertains to child support. And so the statute is Family Code 4055, and you see the calculation there, right? So this is a statewide child support formula, and it looks very complex because it is. Lawyers aren't sitting at their desks with the notepad and pencil and paper trying to calculate what the guideline child support amount is. We have the Dissolution software program that I mentioned. And so even though this formula looks complex, we kind of cheat, and we have the Dissolution. And so some other important statutes that pertain to the child support are Family Code 4053, right? And so these are the important principles that the court looks at when making an order for child support, right? So we can always stipulate to custody arrangements. We can stipulate to child support, right? If it's not guideline, then you have to name certain factors in the stipulation that states why it's still in your child's best interest and some other considerations, but you can always stipulate, right? Parents may not want to do so, but you have that option, and it can save a lot of time and energy if you're able to, right? We're not always able to do that. And so you look at subsection A, it says a parent's first and principal obligation is to support his or her minor children according to the parent's circumstances and station in life, right? So a lot of the times, on a temporary request for guideline child support, we'll see the court just puts in the numbers that are on the Dissolution and then just makes that as an order. You can make their arguments and you can make your pitch that, this is my gross salary, Your Honor. That's what people say. It's like, why are you putting in my gross salary when I only take home the net? And I just say, we saw the formula, we saw the calculation. This is a tax software program, so it takes into account all these different, inputs. And so I can make the argument for a deviation, and I didn't bring that up here, but there are arguments for a deviation for child support, but, a lot of the time the court is going to lean on the Dissolution calculation. We have here where it says that both parties, parents are mutually responsible for the support of their children. The guideline takes into account each parent's actual income and level of responsibility for the children. And you see here also that each parent should pay for the support of the children according to his or her ability. Right? The guideline seeks to place the interests of the children as the state's top priority. Here we have the best interest of the child standard here again, right? And so what I've recently experienced is one of my clients she was let go from her job, right? She was working for a company down in Silicon Valley, and she was let go because of a circumstance where they said that she was doing work that didn't pertain to their job, to her employment on the job, right? And so she's got a termination date. She's, going to get a severance. And so I've had circumstances in the past where folks lose their job and they're saying, look, I lost my job. I need an immediate modification of child support, right? I don't want to pay child support anymore because I don't have my job, or, I lost my job, so I need more child support. And sure, if you put in zero income on the Dissolution calculation, then the amount will adjust. But that's not the end of the analysis. The court looks at, a lot of different factors with regards to, things that we mentioned here. We have folks who have filed a motion to impute income to a party, right? If they're not working. This just goes into the general idea of how guideline child support is calculated, right? So let's just say somebody voluntarily quit their job, right? And, because they wanted an increase or decrease in child support. The court looks at all the factors. So it doesn't look at the fact that you're no longer employed. The court will look that your client is no longer employed. The court will look at, okay, what are the circumstances surrounding the termination, right? Or like I mentioned, my client had a severance. So the court will take that into consideration. You have an obligation to support your children to the best of your ability. So just because you lost one job doesn't mean you shouldn't be applying for, jobs every day of the week, attempting to support yourself and being able to support your children. And so those are some of the things that come up. So it's, even though, they have a guideline calculation, there are other considerations that the court will look at. And it's, again, we go back to the obligation of you being not necessarily a private investigator, but you're going to ask these hard questions. You're going to ask your clients these hard questions. Oh, what is your plan? That's something that I have to talk to the client about, because the court's going to want to know these things. You want to look. David mentioned stability, right? So all of these considerations pertain to child support. They pertain to child custody. It pertains to the dissolution of your marriage. And so it just goes back into like, why can this process take so long? When we were only married for a short period of time, but the divorce is taking 2 times as long as the marriage. And so there's just so many different issues that come up. Folks they fight, argue, have the discussion about custodial time, right? So one client called in, or potential client called in, and he was saying like, look, I want to have custody time with my daughter. I was like, okay, I explained the process to him. I was like, you have to file the papers, you have to serve the other party, you have to, explain, the history of what's been going on, and you'll have to go to mediation. And this may seem overwhelming at first, and it definitely is. They're not just going to make a custody order for a 2-year-old and say, okay, you can go on your merry way, right? We've made these orders. The court is always going to be concerned about what's in the best interest of the child. So you could file a request for order and get a hearing on child custody and parenting time, for your daughter, for your children, and the court will most likely schedule, review hearings, right? The younger the child is, the more frequent you'll have review hearings where the court will want, status updates on what's going on with the child. Has the custodial arrangement been working out for the best interests of the child? Are there things that the court needs to be made aware of, so that you can, if there needs to be a modification? All these things get taken into consideration. And so, like David said, legal custody, it doesn't get changed very easily, but, child parenting time with the child can get modified, but, we have due process. You make your pitch to the judge, you include as many facts without going over the 10-page limit for your declaration that describes why you want the court to make a certain order for custody and visitation, parenting time, right? And so these are the things that we have to talk to our clients about all the time on a continuing basis. Once you get involved in the court system with regards to the dissolution of marriage or the child custody issues, I mentioned at the outset that fiduciary duty continues even after you're divorced, right? I have a client now where they're fighting about RSUs and bonus income because one parent doesn't want to disclose what they're receiving through the job, doesn't want to disclose the bonus compensation they're receiving. And so they've been divorced since 2012, but here we are 10 years later, and they're still going through litigation and issues pertaining to their case, right? I had a case where parents just couldn't get along and they litigated until the kid was 18 years old, And so that just happens where, you're still going to have to parent. You're still going to have to co-parent with your, well, I'm not going to have to, but you're still going to be the parent to the child after the kid's 18. You know what I'm saying? So these are just things that I just try to make sure that the client is mindful of. And I just try to encourage, folks to be honest with how the process is going to work. And, just if they have any questions, just don't be afraid to ask, right? Because it's all a learning process for me as an attorney, for parents, for litigants. And so these are just important things that I thought we could all discuss today, in an MCLE. So did anybody have any other questions about the 3 issues that we discussed?
Hello?
Yes.
Hey, how you doing? My situation kind of covers has a little bit of everything that you talked about.
Mm-hmm.
But mainly my problem's been with the court systems. Like, I've had evidence, I've had proof of everything that I'm supposed to have to show that the mother's not capable of taking care of kids, and even my kids were in the abusive and like I would say molestation way, where her nephews were doing certain things to him, and the judge did not want to look at any of my information. So I mean, what do you do when the court system is just not cooperating at all? Is there anybody above them or what?
So if there's been an order that has been made, you have, they say, about 10 days from when the order has been served and been made to challenge the ruling. They call it a motion for reconsideration. So
Yeah.
that is one option that people consider. And I would want to be persistent with making sure you're following what the statute says in terms of providing things in a timely fashion, providing as much documentation, right, within the time frame that you're supposed to do it. And so those are the things that I would encourage parties to do if you don't feel that the court is, hearing what you have to say. And so I've had circumstances where, there similar, right? Where you make these facts known to the judge, and the court may not see it the way that you see it, right? And so that's when, you know, you can bring up the mediator. We bring up a lot of these things with the mediator, you know, and hopefully you're able to spend some time with the mediator where she or he can do some inquiry into the other party, the behavior that you're mentioning. And so that's, you know, we have a lot of different, you know, avenues of just getting into what's really going on with the kids. And, you know, you really have to bring up what's in the child's best interest, which it sounds like you're doing, and just I would be persistent and, you know, have as much documentation with regards to your position, right?
I was being very persistent with it, but it came to the point where the last time we were in court, the judge, like I said, I had all my evidence, I had everything needed to, you know, to prove that, you know, what I was saying was right. Well, at the end of the case, whatever, he removed the kids from me when I had proof that she had ankle brace, she had everything, you know, and he removed the kids from me and made me have to pay a $1,500 bond in order for me to resume visitation with my kids. So we have the 2-3 split that you were talking about. We have 2-3 split, and he took my visitation and also made me have to pay a bond to see my kids again, and made me have to pay all types of other fees. And I just found out about the whole motion deal, and I've been trying to get other lawyers to, you know, to take it to another courtroom or take it out of his court, but everybody must be scared of him because they say the same thing. You know, if you take it out of his court, then he's going to hold a grudge, or, you know, and then he even threatened me at the end of the case, saying that if I come back in this courtroom again, that his ruling is going to be worse towards me than this time.
So the program that here we were assigned with was, you know, we were making reference to California cases, right? Mm-hmm. And, you know, it was a continuing education course with regards to providing information, you know, with regards to the current laws regarding to these 3 issues. David, were you going to mention something? Oh, I thought.
No, what I was going to say is that if it's at all possible to take your case to a lawyer, even if you're only going to buy an hour's worth of the lawyer's time, sit down with a lawyer and get some independent observation of of the ins and outs of, and some maybe the lawyer can help you structure your argument. That's probably the best initial expense that you can incur. If you're trying to do this on your own and or you have no money to hire a lawyer, you are confronting a fairly substantial bureaucracy, and it will be difficult to get traction in that bureaucracy. It's an unfortunate fact. It should be easier. There should be more options. There should be it should be more accessible to unrepresented clients. Most of the people in the family court system are unrepresented, but most of them go away either angry or happy, but they go away and they don't come back. The people who are angry and keep coming back are an irritant in the system, and the system doesn't do a good job of dealing with it. In theory, the parent who comes in and says the other parent is abusing or not protecting the child from abuse, that's a powerful argument. But if you just make the argument and you don't have police records, or you don't have, you know, physician records, or you don't have eyewitnesses who can confirm that, it sounds like somebody with a sour grapes argument about losing custody. So
I had all of that though.
Yeah, so it's
representation and everything.
Yeah, at the end of the day, nobody is going to be able to diagnose you on a Zoom call. So you need to sit with a lawyer. You know, don't call me, I'm retiring, but maybe you can call Andrew, maybe he can handle it.
Well, I just wanted to say thank you, everyone. We have our contact information here, and this has just been a wonderful experience. Thank you for all your questions. Thank you for your comments and feedback. And if you have any other questions, feel free to reach out to us, and we just like to say thank you again.
Thank you for everyone for coming. Thank you so much, Andrew. Your presentation was really great. Thank you. And thank you, David, for your contribution. Thank you so much.
All right. Thank you.
Bye-bye.